The conscience escape. Hatch does not save Dignitatis. Humanae Christian Wagner's strongest case for continuity confuses objective religious truth with a man's actual judgment, then asks a legal presumption to erase the contradiction. By Chris D. Christian Wagner of Scholastic Answers has presented what may be the most ingenious defense of Vatican II's teaching on religious liberty that I have encountered. In his video Religious Liberty and Tradition, Wagner reviews Fontre Bernard Lucian's recent English language book, Religious Liberty, Continuity or Contradiction. He grants the force of the older teaching, acknowledges that Dignitatis Humanae is weak, ambiguous, dangerous, and readily used for religious indifferentism, and avoids reducing the document to a ban on forced baptism. He nevertheless argues that its central teaching remains true and traditional. The proposed reconciliation rests on one distinction. Gregory XVI and Pius IX condemned a supposed right to act in religious matters as one wishes. Vatican II protects a man's civil liberty to act according to his conscience. Since a man can willingly sin against his conscience, the two formulas are not identical. That distinction is not one argument among many. Lucian's earlier monograph argued that the older and newer teachings contradicted one another. In the present book, he says that conclusion stood only while no possible interpretation in favor of non-contradiction had been found, Peter 29. The new conscience distinction is therefore load-bearing. If it fails in one decisive case, Lucian's former conclusion returns. The distinction is real but does not reconcile the two civil rules. One sincere Muslim missionary defeats it in a Catholic courtroom, while the rest of Dignitatis Humanae defeats the narrow interpretation on the page. The historical record grounds restraint in the objective injury done to God, the faith, and souls, without presuming that every dissenter is lying to himself. Lucian's method then treats any non-impossible harmonization as the authentic meaning of a text whose words, official explanation, and implementation all point the other way. The argument is clever. At its decisive step, it is also sophistical. I have already set out the broader documentary and practical case in Religious Liberty Seats Christ Beside Satan and answered the usual distinction between moral permission and civil immunity in Joe Heschmeyer, quoted the condemnation, then answered a different charge. Wagner's video raises a narrower and stronger objection. This article answers it on its own terms. Lucian's 3 boxes and 1 permit. Wagner helpfully arranges Lucian's theory into 3 cases on his whiteboard. 1. A man acts against his conscience in religious matters. He may be restrained. 2. A man acts against the common good, whether against or for conscience. He may be restrained. 3. A man follows an erroneous conscience without acting against the common good. He ought to be free from coercion. The taxonomy shows where every escape must go. Box 1 depends upon the Catholic state's presumption about conscience. Box 2 requires the common good to supply an independent ground of restraint. Box 3 contains the sincere dissenter whom Dignitatis Humanae protects. Each possibility can be tested without speculating about motives. Begin with a case designed to remove every distraction. A Muslim was born and raised outside the church. He now lives in a Catholic country. He sincerely believes that Islam is true, and that God commands him to invite others to it. He requests permission to rent a hall, preach peacefully to adults, distribute literature, and organize a mosque. He threatens no one, defrauds no one, and violates no independent law protecting life, property, public peace, or decent morals. May the Catholic ruler deny the permit solely because Islam is false, its public spread dishonors Christ, and its success endangers souls? The older Catholic rule says yes in principle. Prudence may counsel or require toleration, but the ruler possesses authority to restrain public religious error for the sake of the true religion and the Catholic common good. Read according to its ordinary sense, Dignitatis Humanae says no. The missionary possesses a natural civil immunity from restraint while he observes just public order. The Declaration protects public worship, instruction, witness, organization, buildings, and efforts to shape society according to religious doctrine. Lucian tries to deny the permit through his first box. He says that in a Catholic society, the ruler may presume public acts against Catholicism to be acts against conscience. The truth of the Church and her motives of credibility are public knowledge. Public heresy, schism, infidelity, blasphemy, and sacrilege may therefore be restrained because Dignitatis Humanae protects only conduct that follows conscience. But I have stipulated the Muslim's sincerity. He is wrong, perhaps culpably wrong, yet he actually judges that his missionary work is a duty before God. What happens to his permit? If he is protected, the contradiction returns. Vatican II gives him an immunity the older doctrine denied. If he is not protected, according to conscience no longer means according to the concrete judgment he is actually following. It means according to the judgment the state thinks he should have reached. The theory has silently changed its definition in the middle of the case. There may be a third vocabulary, there is no third ruling on the permit. The distinction is real and still misses. Traditional moral theology distinguishes the objective norm from the judgment of conscience and from the subsequent choice of the will. Conscience does not create good and evil. It applies known principles to a concrete act here and now. That realist account allows for an erroneous conscience. Aquinas asks directly whether an erring conscience binds and answers that every will at variance with reason, whether right or erring, is always evil. Summa Theologiae Curator 19, A5. A man may sin by following a culpably erroneous conscience because he is responsible for the error. He would also sin by choosing what he presently judges to be evil. Lucian accepts this. His book expressly distinguishes the man who acts against conscience from the man who acts according to a culpably erroneous conscience. That concession decides the stipulated case. The Muslim's error may be vincible, sinful, and disastrous to others while remaining the error his practical reason actually applies to his missionary act. This is not an appeal to sincerity as a source of moral rights. Sincerity cannot make Islam true, public proselytism good, or the religious common good disappear. I introduce sincerity because Lucian makes actual conformity to conscience the object of Vatican II's civil immunity. One sincere dissenter is enough to test that claim. The older civil rule did not depend upon finding secret bad faith. It judged the outward act according to objective truth and the common good. Aquinas forbids compelling pagans and Jews to believe because faith depends upon the will. In the same answer, he permits their outward attacks on the faith to be restrained, including blasphemies and evil persuasions. Summa Theologiae Dissertationibus, Q10, A8. When he considers the rights of unbelievers, he says they may be tolerated for a good obtained or an evil avoided. He does not derive their toleration from a natural civil immunity carried by sincere error. Artus 2, Curator 10, A11. The distinction between wishing and conscience therefore proves too little. The question is whether peaceful public error acquires a claim against the ruler whenever the person performing it happens to follow his erroneous judgment. The older authorities did not make that exception. Pius IX condemned a civil rule, not merely a state of mind. Wagner places most of the weight on the language of absolute liberty in Quanta Cura. Pius IX condemned a claimed right by which citizens could publicly manifest any ideas whatever without restraint by ecclesiastical or civil authority. Lucian reads that as liberty to act as one wishes, which is broader than liberty to follow conscience. That language is present, but the condemnation begins earlier. Quanta Cura first condemns the proposition that the best civil order recognizes no duty in the civil power to restrain offenders against the Catholic religion, except where public peace requires it. That proposition concerns the ground and competence of civil restraint. It says nothing about restricting penalties to people proved to be acting against their own consciences. Put the two limit clauses beside each other. Pius IX condemns, civil authority has no duty to restrain offenses against Catholicism, except so far as public peace may require. Vatican II teaches, religious exercise may not be impeded, provided just public order be observed. The clauses are not verbally identical, and just public order may be broader than public peace. They nevertheless address the same juridical question. What authority remains once the stated civil limit has been satisfied? The conscience distinction does not answer that question unless Lucian's presumption moves the sincere dissenter into the first box, or the common good moves public religious error as such into the second. Those are the two claims that require proof. Even if Lucian's narrower lexical reading of every relevant line in Gregory XVI's were granted, this proposition from Pius IX would remain. One countertext in the older magisterium is enough to defeat the claim that the popes condemned only a civil liberty broad enough to cover conduct against conscience. The accompanying syllabus is equally awkward for Lucian. Proposition 15 does not speak of a man doing whatever he wants. It condemns the claim that every man is free to embrace and profess the religion he judges true by the light of reason. The syllabus must be read through the documents it indexes, but the wording alone prevents the 19th century record from being reduced to one formula about arbitrary desire. Leo XIII supplies the governing category in Libertas. He teaches that a Catholic state must preserve and protect the true religion, rejects equal juridical standing for false worship, and permits toleration when the public welfare supplies a just cause. Toleration must remain confined to the cause that justifies it. These principles concern objective goods, public authority, and the ruler's duty. Leo never says that false public worship becomes immune when performed according to an erroneous conscience. The old formula was not restrain only the consciously dishonest. It was authority may restrain while prudence may tolerate. The presumption does not follow. Lucian knows that civil authority cannot inspect a soul directly. His solution therefore turns upon a presumption. Catholicism possesses objective signs of credibility accessible to all, and in a Catholic society, its essential dogmas and laws are publicly known. He concludes that a ruler may presume someone who publicly acts against Catholicism to be acting against his conscience. The conclusion does not follow. Objective truth, culpability for missing it, and the concrete judgment a person actually makes remain distinct. A truth may be available, and a man may be blameworthy for failing to embrace it, without his mind already possessing the opposite judgment from the one he professes. Vatican I taught that the Church is adorned with evident marks of credibility. It then drew a special conclusion about people who had already received the faith under the Church's teaching. They can have no just cause for abandoning or doubting it. De Filius, chapter 3. It did not declare that every pagan, Muslim, and Protestant shown those signs inwardly judges Catholicism to be true. The Council also defined supernatural faith as a free act moved by grace. Motives of credibility make faith reasonable. They do not force the intellect into actual supernatural assent. Vatican II made that last distinction dogmatically sharp. Canon 5 on faith anathematizes the claim that Christian faith is not free, but is necessarily produced by arguments of human reason. This canon does not prevent a court from drawing a prudential conclusion about culpability from external evidence. It does prevent motives of credibility from being treated as demonstrations that necessarily produce the actual assent Lucian assigns to the dissenter's conscience. A rebuttable inference remains possible, but then the sincere Muslim can rebut it. A judgment that Catholicism is credible, supernatural assent to Catholic revelation, and the concrete judgment of conscience remain distinct acts. Lucian's theft analogy conceals the gap. A judge may presume that an ordinary adult knows the natural precept against theft, and recognizes that goods in another man's possession are not his. The existence of God, the Trinity, the Incarnation, the divine mission of the Church, and the claims of Muhammad are not facts known in that same immediate way. They involve history, testimony, grace, upbringing, argument, and sometimes generations of inherited error. Unbelievers do not thereby receive a general excuse. The limited conclusion is that culpable error does not establish conscious dishonesty. The legal presumption is circular for another reason. A presumption of imputability normally operates after an external violation of a valid law has been established. Here the disputed question is whether the ruler may make peaceful false proselytism legally restrainable in the first place. Canonical presumptions, criminal imputability, and just war judgments show that authority may judge culpability from external evidence. They do not establish that every public non-Catholic act proceeds from a hidden judgment in favor of Catholicism. The state cannot prove its jurisdiction by presuming guilt from the violation of the very law whose legitimacy is under dispute. Make the presumption rebuttable, and our sincere Muslim rebuts it. His activity becomes protected, and the older and newer rules divide again. Make it irrebuttable, and the civil right no longer follows actual conscience. A legal fiction has replaced the fact that supposedly grounds the right. That substitution is the sophistical turn. Lucian begins with what conscience actually judges, moves to what conscience objectively ought to judge, and returns speaking as though the two had remained identical. The Council's own text rejects the narrow reading. Wagner emphasizes the central doctrinal sentence in Section 2. He argues that surrounding explanations can be weak or erroneous without compromising the proposition authoritatively taught. A conciliar relator did distinguish the teaching being proposed from its supporting argumentation. That distinction about levels of authority is legitimate. It does not permit an interpreter to detach a sentence from the document that defines its terms, enumerates its applications, and explains its legal consequences. Section 2 of Dignitatis Humanae grounds the right in human nature rather than subjective disposition. It says the immunity continues even in those who fail in their duty to seek and adhere to religious truth, provided just public order is observed. Lucian's own answer concedes that one who does not satisfy the obligation mentioned preserves this right. That much is true. P. Nurs 13. He correctly adds that such a man may act according to a vincibly erroneous conscience. Our sincere Muslim is exactly that man. Section 3 makes the subjective reference unmistakable. Religious inquiry occurs through teaching, communication, and dialogue in which men explain the truth they have discovered or think they have discovered. It then says a man is not to be restrained from acting according to conscience. The Council expressly places mistaken discovery inside the protected process. Section 4 grants religious communities freedom to worship publicly, instruct members, select ministers, erect buildings, teach, bear public witness, organize institutions, and propose their doctrine for the ordering of society. Communities as such do not possess a personal act of conscience. Their institutional rights cannot be administered by asking whether every minister, teacher, donor, and congregant is privately following his own judgment. Section 6 requires the government to safeguard the religious freedom of all citizens. Even where one religion receives special civil recognition, the rights of every citizen and religious community must be made effective. Equality before the law may not be violated for religious reasons, and government may not hinder a person from joining or leaving a religious community. The apostate is the presumption's strongest possible case, not a marginal complication. He received the faith under the Church's teaching, and Vatican I says he can have no just cause for abandoning it. If public evidence ever warranted Lucian's presumption, it would warrant it here. Dignitatis Humanae nevertheless says the civil government may not hinder a man from leaving his religious community. His departure may be objectively false, culpable, and contrary to duties already accepted. The civil immunity remains where Lucian's escape hatch should work best. Section 7 then defines public order through the rights of all citizens, the settlement of conflicts of rights, genuine public peace, and public morality. It commands freedom in its full range and permits curtailment only when necessary. These passages tell rulers, courts, religious bodies, families, and citizens what the announced right does. Their legal applications belong to the meaning of the teaching, even if its supporting arguments carry a different level of authority. The relator closed the proposed escape hatch. The history of the text confirms the ordinary reading. This evidence is not itself magisterial, and it cannot override the promulgated words. It matters when someone claims that a novel restriction is the literal meaning of those words. In his official explanation of the 1964 schema, Bishop Emile de Smet told the Council Fathers that public authority could restrict religious exercise when it seriously harmed public order. He then excluded 3 grounds for restraint: that the religion is false, that its practice proceeds from an erroneous conscience, or that it harms the good of the Church. Such action, he explained, would be directed against religion as such. He also said that a state religion could remain, but only alongside religious liberty and equality in public law. Acta Synodalia Thurs. B8, pp. 462-463. Wagner himself appeals to the conciliar relator to distinguish the proposition taught directly from the supporting considerations. That appeal makes the same official explanation especially difficult to evade when it identifies the proposition's juridical content. The relator does not become decisive when he narrows what carries doctrinal weight, and irrelevant when he excludes falsity, erroneous conscience, and injury to the Church as grounds of restraint. That is almost a point-by-point rejection of Lucian's reading. Lucian responds that the opinions expressed during drafting are less decisive than the final text read within the whole prior magisterium. The general rule is sound, but the final text retained the same public order boundary, protection for erroneous conscience, rights of religious communities, and legal equality. The relatio and the promulgated declaration point in the same direction, which makes the narrow reading untenable as literal exegesis. The common good cannot swallow the defined right. Wagner correctly rejects a secular idea of public order limited to traffic, property, and quiet streets. God is man's final end. Civil society has a proximate temporal end, but that end remains subordinate to man's supernatural end. A Catholic ruler cannot reason as though eternal salvation were none of his concern. This strengthens the older doctrine without proving Lucian's interpretation of the Council. The modern catechism says the limits of religious liberty must be judged by political prudence, according to the common good and legal norms conforming to the objective moral order, sections 2108 to 109. Read alone. That language sounds broad. Read with the definition it is interpreting. It cannot mean that religious falsity and spiritual harm automatically remove the immunity. This is Wagner's second box. It works without controversy when a religious act violates an independently valid law protecting life, property, peace, or public morality. The disputed move is to place peaceful public error in that box simply because false religion harms the Catholic common good. If public false religion as such violates the common good in the relevant legal sense, a Catholic state may restrain nearly every distinctive public act of every false religion. Sections 2, 3, 4, 6, and 7 would be left protecting little more than private thoughts and whatever conduct the ruler already judges religiously sound. The announced natural right would collapse back into conditional toleration. If public falsity as such does not defeat the immunity, the older Catholic competence remains excluded. Wagner says a Catholic society may punish heresy, infidelity, blasphemy, and sacrilege as such because it may presume them contrary to conscience. The stated ground shows otherwise. On his theory, they are restrained as presumed acts of inward disobedience, not because public religious error objectively lacks a claim against Catholic authority. Establish one sincere offender, and the supposed preservation of the older rule disappears. The same problem attends the claim that Dignitatis Humanae permits confessional states. Section 6 indeed allows special civil recognition of one religion. It simultaneously demands effective religious liberty for all communities and forbids religious discrimination. A constitution may retain the word Catholic, while the state loses the older authority to protect Catholic unity against peaceful public proselytism. Such a state possesses less religious jurisdiction than the older doctrine assigned it. The Council of Vienne did not read Muslim minds. Asked about the Council of Vienne's restriction of Islamic practice, Wagner answers that older Catholic authorities could presume such acts culpably violated conscience. The decree itself gives different reasons. The council complained that Muslim clerics publicly invoked Muhammad from their mosques in lands subject to Christian princes. It called the practice an insult to the holy name, a disgrace to the Christian faith, and a scandal to the faithful. It commanded Catholic rulers to forbid the public invocation. Council of Vienne, Decree 25. The decree does not say that the Muslim clerics secretly knew Catholicism was true. It judges the public act, its object, and its effect upon the Christian commonwealth. Whether every Muslim caller possessed an erroneous conscience through personal fault would affect his guilt before God. It would not change what the public call honored or what Christian ears were made to hear. The same objective structure appears in Aquinas and Leo XIII. Error may be tolerated for the common good. It does not acquire a natural civil title because the man spreading it is sincere. The word tolerated carries juridical weight in this tradition. In the classical argument, a ruler tolerates an evil he has authority to forbid because prohibition would cause a greater evil or prevent a greater good. He does not tolerate the exercise of a natural civil immunity that lies beyond his competence. If Lucian's third box describes a perennial natural right, Vienne did not merely apply a stricter policy to Muslim worship. It commanded Christian princes to violate that right. The proposed escape would preserve the Council's words by placing the older Church's public deeds under judgment. Lucien's proposed rationale therefore cannot be read out of the decree he invokes. Its grounds are the objective offense and scandal caused by the public act. Changed conditions. Explain toleration, not a new natural right. Wagner argues that the presumption possible in Christendom is generally impossible now. Catholic truth is no longer public knowledge throughout religiously divided societies, so broad freedom is often required. The older doctrine already has a category for this situation: toleration. A ruler may decline to restrain error when restraint would cause greater evils, disrupt peace, obstruct conversion, or exceed what his fractured society can bear. Different circumstances can produce very different laws without changing the underlying allocation of authority. Lucien's theory instead makes the operation of a natural civil right depend upon the religious demographics and presumed mental condition of a country. The man possesses immunity where Catholic evidence is socially obscure, but loses it when the same evidence becomes publicly available, even though he makes the same sincere judgment and performs the same peaceful act. Human nature did not change when he crossed the border. Only the state's willingness to believe him did. Spain supplies a documentary test. Wagner says on the stream that specifically in law there was not a criminalization of public non-Catholic religious acts under Franco. If he means that Article 6 of the Constitutional Charter did not itself state a criminal penalty, the point may be technically correct. It leaves out what that article actually enacted. The 1945 Fuero de los Españoles protected private, non-Catholic worship and then declared, no se permitirán otras ceremonias ni manifestaciones externas que las de la religión católica. Only Catholic public ceremonies and manifestations were permitted. A legal prohibition denies civil immunity whether its enforcement is criminal, administrative, or supplied by another law. The 1967 Religious Liberty Law guaranteed private and public religious practice and protected religious teaching by speech and writing. Its preamble said Dignitatis Humanae made alteration of the old rule necessary and recorded the Holy See's prior approval of the new wording. Spain remained officially Catholic. It therefore became the exact kind of confessional state Wagner says the Council permits, Catholic in constitutional recognition, but bound to make non-Catholic public liberty effective. The record need not prove every post-conciliar appeal to religious liberty correct. Taken together, it shows that the broad reading was not invented decades later by secular bishops. A Catholic confessional state revised a concrete legal prohibition because of Dignitatis Humanae, with the Holy See's prior approval. The claim of infallibility needs more than a link to revelation. Wagner follows Lucian in making a still larger claim. The central teaching of Dignitatis Humanae is said to be infallible because the Council presents it as based on revelation. Earlier teaching is also infallible. A contradiction is therefore impossible, and a non-contradictory interpretation must be accepted even if its positive theological justification cannot be established. The conclusion outruns the premise because a doctrine may be related to revelation, supported by revelation, or judged consonant with revelation without being proposed as divinely revealed or definitively to be held. Dignitatis Humanae 9 says its doctrine has roots in revelation, then immediately concedes that revelation does not affirm the civil right in so many words. That is not a formula manifesting definitive intent. Lumen Gentium 25 teaches that the bishops dispersed throughout the world teach infallibly when, while maintaining communion with one another and the Pope, they agree upon a judgment as definitively to be held. The later CDF commentary on the Professio Fidei likewise distinguishes definitive teaching from authentic non-definitive teaching. A doctrine does not become definitive merely because a document says revelation supports it. Definitive intention must be shown from the tenor and context, or the proposition must already belong to the Church's uninterrupted definitive teaching. That latter route is unavailable without begging the question. The novelty under dispute is precisely a natural civil immunity for public false religion. Paul VI explained after the Council that Vatican II had avoided extraordinary dogmatic definitions carrying the note of infallibility, while its teachings retained the authority of the supreme ordinary magisterium, and were to be received according to each document's nature and purpose. General Audience, January 12, 1966. His statement does not prove that Vatican II contains no restatement of previously infallible doctrine. It does rule out treating Lucian's specific inference as obvious. Religious submission is a real Catholic duty. Authority is not flat, and submission does not turn an unproved interpretation into the meaning of a text. Before the demand for submission can settle this controversy, the level, object, and meaning of the teaching must be established. Those are the disputed questions. Non-impossible is too low. A standard Lucian's method completes the defense. A Catholic must presume harmony among authentic magisterial texts. If a new text bears two literal readings, one continuous and one contradictory, he must accept the continuous reading. The critic bears the burden of proving contradiction. Lucian says the defender needs to establish only the non-impossibility of his interpretation. Lucian is admirably candid about the modesty of that claim. After revisiting the earlier work in which he thought he had established contradiction, he says he must adhere to Dignitatis Humanae even if I cannot positively justify this new doctrinal statement through sound theological arguments or positively establish its continuity with the older teaching, Peter 29. That may explain why he feels bound to keep searching. It does not establish that the narrow proposition is what the Council asserted. He later reasons that if the new distinction is required to reconcile the magisterial texts, that need itself makes the distinction grounded in magisterial authority and traditional in substance, Peter 32. To his credit, his next sentence says the distinction must also be intrinsically fit to remove the contradiction. That qualification prevents the sentence from being a purely automatic canonization of any rescue device. It also returns the whole dispute to the test Lucian cannot avoid, whether his distinction actually preserves the same civil ruling in the sincere case. The initial presumption is sound, the proposed burden is not. A presumption of continuity tells a Catholic to read carefully, distinguish senses, and resist a reckless accusation of error. It does not license him to discard the ordinary meaning of a text once he can imagine a technically possible rescue. Interpretation seeks the proposition actually asserted, not the last proposition that could survive ingenuity. Lucian compares the method to reconciling apparent contradictions in Scripture. The analogy assumes what it needs to prove. Inspiration supplies a defined guarantee that both scriptural passages are true. Whether an equivalent guarantee covers this specific, non-defining civil proposition is part of the present dispute. Even with Scripture, a merely possible story does not solve a contradiction if the words in context exclude it. Wagner also compares Lucian's task to a theologian expounding Nicaea, Chalcedon, or Vatican I without waiting for a second magisterial act to explain the first. A theologian plainly may explain and synthesize authoritative texts. That freedom does not establish that his proposed synthesis is the literal meaning. Here the operative sections of the Declaration, the official relator, and the immediate legal implementation all oppose the restriction the theologian wants to insert. Calling the restriction literal cannot do the work of finding it in the text. Here the supposed narrow reading faces the full declaration, the rights of communities, the freedom to leave a religion, the public order definition, the relator's explanation, the immediate Spanish application, and the older objective rationale. Its defenders cannot answer all that by repeating that their construction is not metaphysically impossible. The burden of proof does not require proving that no sequence of words could ever carry Lucian's meaning. It requires holding one public act still and showing that the two authorities allocate the civil claim differently. The sincere Muslim case establishes that difference without speculation about every possible wording, what Wagner gets right. Wagner's presentation deserves credit for refusing the weakest modern conservative answers. He recognizes that the older teaching concerns real coercive authority. He does not confuse civil immunity with moral approval. He affirms objective truth, a realist conscience, the subordination of temporal society to man's final end, and the possibility of Catholic establishment. He also treats Dr. Lucian's difficult book as a book review and admits that he has more research to do. Those concessions locate the remaining failure in his use of conscience within public law rather than in his abstract definition of conscience. An erring conscience can actually bind. A government cannot infer its contrary merely from the public availability of evidence. The older civil rule judged objective acts and public goods rather than making a dissenter's hidden judgment the source of jurisdiction. Dignitatis Humanae protects mistaken discovery, communities, public teaching, entry into religion, departure from religion, and equal civil liberty under a public order limit. The Council's relator excluded falsity, erroneous conscience, and harm to the Church as sufficient grounds for restraint. Spain then changed its law in the direction those words naturally require. Lucian has found a real verbal distinction. His own three-box application shows why it does not square the civil circle. The sincere Muslim belongs in the third box and on Lucian's terms ought to be free. Moving him into the first box requires the false presumption that accessible truth is already his actual judgment. Moving him into the second requires false religion as such to violate the limiting order, which reduces the announced right to toleration. The permit must still be granted or denied. Grant it because the Muslim follows his conscience, and Vatican II has conferred an immunity the older rule denied. Deny it because Catholicism is objectively available, and the state has replaced the man's actual conscience with the judgment it believes he ought to possess. Neither answer produces continuity. One concedes the reversal. The other conceals it behind a presumption.